Courts of Justice Act, Court of Appeal for Ontario creates new rule? As a licensed insolvency trustee, formerly called a bankruptcy trustee, LIT, what really caught my eye in the Court of Appeal's decision was something that I doubt any lawyer is going to write about when analyzing this case. What I am talking about is two sentences near the end of the decision under the heading "The Receiver's Conduct." I feel these two sentences are so important that in certain cases, it will create a new rule for receivers. By extension, it will also affect all stakeholders in the receivership and give all legal counsel something serious to think about. The two sentences are so important, I will show them to you here. 2. The receiver's conduct. The receiver argues that it was appropriate for it to close the transaction in the face of a threatened appeal because the appeal period had expired when the appellant advised the receiver that it was contemplating an appeal, without having filed a notice of appeal or a request for leave, and the receiver was bound by the provisions of the purchase and sale agreement and the order of the motion judge, which was not stayed, to close the transaction. Generally speaking, as a matter of professional courtesy, a potentially preclusive step ought not to be taken when a party is advised of a possible pending appeal. However, here the receiver's conduct in closing the transaction must be placed in context. The Court of Appeal held that the receiver's conduct in completing the sale prior to the expiry of the appeal period was proper. Why is this so important? Now I am at the point of this Brandon's blog. The reason I am writing this. The real heart of the matter. To understand the importance of these two sentences, I must provide you with some additional background information. In June 2004, the Ontario Court of Appeal released its decision in Regal Constellation Hotel Limited, Re. 2004 Conley 206, on CA, the Regal Constellation case. The main points decided in that case were: there is no automatic stay of a vesting order under appeal. There must be an application to stay it while the appeal is outstanding. Once a vesting order is registered on title under the Land Titles Act, its features as a conveyance prevail and its features are spent. A registered vesting order cannot be attacked except by ways that apply to any type of order transferring outright title and registered under the land titles system. Appeal from a registered vesting order is moot. The Court of Appeal for Ontario stated in the Regal Constellation case that a vesting order has a double personality. It is, on the one hand, a court order and also a conveyancing tool. Vesting an interest in real or personal property is stated in the order. As soon as a vesting order has been registered on title, its features and characteristics as an order are spent. Any appeal at that stage is therefore moot. So why is it so important? As a result of the Regal Constellation case, receivers and their legal counsel always ask the purchaser's legal counsel, do they wish to close the transaction immediately or wait for the appeal period to expire? I have been involved in many real estate receiverships where the closing is teed up to begin as soon as the vesting order is issued and entered. Everyone leaves the courthouse and goes straight to the closing. Registering the vesting order against the lands is part of the closing process. Some buyers will certainly reject the option to complete the transaction before the period to appeal the vesting order has actually run out. Others are prepared to close immediately due to the fact that the chance of overturning the sale approval and setting the transaction aside is incredibly remote. This is especially so if the closing has actually taken place. Nowhere in the Regal Constellation case is the conduct of the receiver scrutinized. The new rule for court-appointed receivers. So the new rule for court-appointed receivers is that the receiver and its legal counsel will carefully have to consider in each situation, is the immediate closing of the transaction a reasonable thing to do? I can think of 8 issues to consider because of those two sentences in the Dionor decision. Has an actual appeal been filed in time? Has any party threatened an appeal prior to the 10-day appeal period expiring? Say the situation is that the vendor receiver and the purchaser has the option of completing the transaction prior to the 10-day appeal period expiring and there is no threatened appeal. Does the receiver now have a duty, or at least cover off the point, to put all stakeholders on notice that the closing, including the registration of the vesting order, will take place prior to the expiry of the appeal period? Should a discussion be held with a potential purchaser who has submitted an agreement of purchase and sale that the receiver believes it can work with regarding whether the agreement should stipulate whether or not the closing must take place prior to the expiry of the appeal period? Should the court-appointed receiver's terms and conditions of sale to be approved by the court now state that any bidder must stipulate that the bidder must stipulate whether or not it wishes to have the option to complete a court-approved transaction prior to the expiry of the appeal period? Similarly, must the court-appointed receiver's standard agreement of purchase and sale to be approved by the court contain a right for the bidder to be able to elect in writing whether it wishes to complete the transaction prior to the expiry of the appeal period? If its bid is recommended by the receiver and approved by the court, must such an election be made prior to the court approving the proposed transaction, so that all stakeholders are aware at the time court approval is sought that such a possibility may exist? Is the bidder having such an option to elect prior to obtaining court approval sufficient, or to better protect the vendor receiver and the purchaser, must the election be made so that such election can also be approved by the court? As I said before, this is not the focus of the Dionor decision. I doubt many or any writers analyzing this case will focus on those two sentences. However, as the lit who will be the court-appointed receiver, in my humble opinion, I think those two sentences in the Dionor decision now give receivers things to think about that was not the case based on the Regal Constellation decision. Courts of Justice Act Summary. Is your business in financial distress because you cannot collect your billings? Do you not have adequate funds to pay your creditors as their bills do you come due? Are you a secured lender and your borrower is in default and you are considering your enforcement options? Does it appear that applying to the court for the appointment of a receiver is your best realization strategy? If so, call the Ira Smith team today. We have decades and generations of experience assisting companies looking for financial restructuring, a debt settlement plan and to avoid bankruptcy. We also have the same experience in assisting secured creditors in realizing on their security and maximizing the proceeds through a receivership process. Call the Ira Smith team today. Courts of Justice.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.
Ow.